Here's a question I get all the time. Should I get a trust or just stick with a will? And here's what usually happens. Someone tells you that you need a trust, that wills are outdated, that probate will destroy your family's wealth. Or someone else tells you trusts are only for rich people and you're wasting money if you get one. So which is it? I'm going to walk you through 3 real life scenarios that will show you exactly which one you need. And I'm going to bust some of the biggest myths about both trusts and wills that even some financial advisors get wrong. By the end of this video, you'll know exactly which estate planning tool fits your life. Let's get into it. Trust explained. What is a trust? A trust is a legal entity that holds assets for beneficiaries. Think of it like a container that owns your stuff, managed by someone you choose. Here's the basic structure. You're the grantor, the person who creates the trust. You name a trustee, the person who manages it. And you name beneficiaries, the people who benefit from it. Types of trusts. There are dozens of types of trusts, but let's focus on the big one most people talk about, the revocable living trust. A revocable living trust means revocable. You can change or cancel it anytime while you're alive. Living, you create it while you're alive, not at death. Here's how it works. You create the trust, you transfer or fund all of your assets into it, your house, your bank accounts, your investments. You're the trustee while you're alive, so you still control everything. When you die, the successor trustee you named takes over and distributes the assets according to your instructions. The key, assets in the trust bypass probate completely. Here's where trusts get powerful. 1. Probate avoidance assets. In a trust, don't go through probate. Your family gets access immediately, no court process, no public record, no delays. 2. Incapacity planning. If you become incapacitated, dementia, coma, whatever, your successor trustee can manage the trust assets immediately. With a will, someone would need to go to court to be appointed as your conservator. 3. Privacy. Trusts are private documents. No one knows what you owned or who you left it to unless you tell them. 4. Multi-state property. If you own property in multiple states, a will means probate in every state. A trust means no probate anywhere. But trusts aren't perfect. Here are the downsides. Cost. Creating a trust costs more upfront. Complexity. You have to actually fund the trust, meaning you have to transfer assets into it. This requires changing deeds, retitling accounts, and ongoing maintenance, all of which we help. Overkill for some. If your estate is simple and small, a trust might be unnecessary complexity. Real life scenarios. Scenario 1, the young professional. Let's meet Sarah. She's 32, single, no kids. She's got $150,000 in savings and retirement accounts, a car worth $25,000, and she rents her apartment. Does Sarah need a trust? Probably not. Here's why. Her retirement accounts and life insurance can name beneficiaries directly, so they bypass probate anyway. Her other assets are modest. She has no property in multiple states. She's not worried about privacy. What Sarah needs: a will that's customized to her, that names who gets her assets, specifies her funeral wishes, and names someone to handle her estate. Total cost anywhere from $500 to $1,500. Maybe a power of attorney for her financial affairs, an advance directive for her health care in case she becomes incapacitated, but a trust? Maybe that's expensive overkill. Scenario 2, the growing family. Now meet Marcus and Jennifer. They're both 38, married, 2 kids, 8 and 10. They own a house worth $450,000 with a $200,000 mortgage. They've got $300,000 in retirement accounts, $100,000 in savings, and 2 cars. Do they need a trust? This is where it gets interesting. They could go either way. Arguments for a will. Their estate is relatively straightforward. Probate costs on a $650,000 estate might be anywhere from $20,000 to $45,000, which is significant but not devastating. A will could cost them between $950 and $1,500 total. Arguments for a trust? The big one. Incapacity planning. If one of them becomes incapacitated, the survivor can keep managing trust assets immediately without court involvement. This is especially important with kids who depend on them. Also, they can structure distributions to their kids. Instead of the kids inheriting everything at 18, they can say, our kids get 25% at 25, 25% at 30, and the rest at 35. And if they ever buy a vacation home in another state, the trust avoids dual state probate. What I'd recommend for Marcus and Jennifer, get the trust. Yes, it costs more upfront, anywhere from $4,500 to $5,500, but the incapacity protection alone is worth it when you have minor children. Plus, they're at an age and asset level where they'll likely accumulate more wealth, making the trust more valuable over time. And here's the critical part. They also need a pour-over will. This is a safety net that says if anything we forgot to put into the trust goes into the trust after death. Because here's a dirty secret. Lots of people create trusts and they forget to fund them. That's why here at the firm, we directly work with clients to fund all the trusts we create. Scenario 3, the blended family, business owner. Finally, meet Robert. He's 55 on his second marriage. He has 2 adult kids from his first marriage, and his current wife has a teenage son from her previous marriage. Robert owns a small business worth about $800,000, has $500,000 in real estate investments, and $400,000 in retirement savings. Does Robert need a trust? Absolutely, without question. Here's why this situation is complex. Blended family dynamics. Robert wants to provide for his wife while ensuring his biological kids inherit his business. A will alone makes this messy. If he leaves everything to his wife, his kids could get cut out after her death. If he splits things evenly, his wife might not be provided for. A trust can create a structure like this. My wife receives income from the trust for life. When she dies, the principal goes to my biological children. Number 2, business continuity. Robert's business can sit in probate for 18 months. It would collapse. A trust allows immediate transition. He can name his daughter as successor trustee with instructions on running or selling the business. Number 3, privacy. Business valuations and clients are confidential. Probate makes everything public, potentially exposing business secrets and client relationships. Number 4, tax planning. At this asset level, Robert might face estate taxes. Trusts can include provisions that minimize tax burden. Real estate complexity. With investment properties, probate in multiple states is almost guaranteed without a trust. So what does Robert need? A comprehensive estate planning, including a revocable living trust as the centerpiece, a pour-over will as a backup, possibly an irrevocable life insurance trust if he has large life insurance policies, definitely powers of attorney, both for healthcare in the form of an advance directive and for finances in the form of a durable power of attorney. Total costs could be anywhere from $5,000 to $10,000, but it could save his family hundreds of thousands in taxes, probate costs, and business disruption. Myths and misconception. Myth 1. Trusts are only for rich people. False. While trusts make more sense as assets increase, plenty of middle-class families benefit from trusts. If you have minor kids, own a business, have property in multiple states, or have a blended family, a trust might make sense regardless of your net worth. Myth 2. A will is enough for everyone. Also false. Wills are great for simple estates but have limitations. They don't help with incapacity, they don't avoid probate, they don't give you control over distributions over time. Myth 3. If I have a trust, I don't need a will. Wrong again. You need both. The will acts as a safety net for anything you forgot to put in the trust. Plus, wills are where you name guardians for minor children, which you can't do in a trust. 4. Trusts completely avoid taxes. Nope. A revocable living trust doesn't provide any tax benefit. You still pay the same income and estate taxes. There are irrevocable trusts that can reduce taxes, but those are different beasts entirely. Myth 5. Once I create a trust, I'm done. Absolutely not. Trusts require maintenance. When you buy new property, you need to transfer or fund it into the trust. When you open new accounts, they should be in the name of the trust, or at least named as a beneficiary of the account. If you don't maintain it, assets outside the trust still go through probate. The decision framework. You probably just need a will if you're young with minimal assets, you're single with no dependents, your estate is fairly simple and straightforward and under, let's say, $200,000. All your major assets have named beneficiaries. You don't own real estate or business interests. You're okay with probate. You should seriously consider a trust if you have minor children and want incapacity protection, you own a business, you own real estate in multiple states, you have a blended family with complex distribution wishes, you want to control how and when heirs receive assets, you value privacy, your estate exceeds $500,000, you want to avoid probate delays. The bottom line decision tree. Here's the simplest way to think about it. Ask yourself, do I need control, privacy, and efficiency more than I need to save $2,000 to $3,000 up front? If that's a yes, then get a trust. If a no, then a will is probably fine. But remember, you can always start with a will and create a trust later as your life gets more complex. So here's the truth. There's no one-size-fits-all answer. Sarah, the young professional, will. Marcus and Jennifer with 2 kids, trust. Robert, the business owner with a blended family, definitely trust. But here's what I want you to take away from this. The biggest mistake isn't choosing the wrong tool. The biggest mistake is choosing nothing at all. Whether you go with a will or trust, having something is infinitely better than having nothing. Dying without an estate plan means the state makes all your decisions for you. Your family faces maximum cost, maximum delay, and maximum stress. Don't let that happen. Here's what you should do this week. 1. Take inventory of your assets. Write down what you own and what it's worth. 2. Think about your goals. Who do you want to provide for? What concerns you most? Privacy, control, costs? 3. Schedule a consultation with an estate planning attorney. Most, including us, offer free initial consultations. Talk through your situation and get professional advice. And look, I know estate planning feels like something you'll do someday, but someday has a way of never coming. So, Make this the week you actually do it. If this helped you understand the trust versus will decision, smash that like button and subscribe for more personal finance content that actually makes sense. And here's my question to you. Do you have a will or a trust set up? If not, what's your biggest hesitation? Drop it in the comments. I read every single one and I'd love to hear from you. Thanks for watching, and I'll see you in the next video.